Hi, this is the first episode of Bite-Sized Estate Planning. My name is Will Ha. I'm an estate planning attorney. I do wills, trusts, and I help people avoid probate. Today, I'm going to talk about how the most important planning document costs nothing to draft and is very simple and straightforward. This document is called an Advance Healthcare Directive. In the California Probate Code, under the Uniform Healthcare Decisions Act, the law allows people to define their healthcare in advance, beforehand. It also allows people to choose certain people to speak on their behalf if they can't speak for themselves. So, what does this mean? Most of these decisions come into play when it comes to a patient being incapacitated. So, when it comes to treatment, they could specify, for example, if they're unconscious, whether or not they want to prolong their life, or if they want to be taken off life support after a certain amount of days under life support. If a patient is a cancer patient and they're unconscious, and they may decide that they do not want to undergo cancer treatment in that manner, they could absolutely specify that. When it comes to selecting who you can speak on your behalf, a patient might want their daughter, who is a nurse who works at a hospital setting, to make healthcare decisions as opposed to the husband, simply because her daughter has a lot more subject matter expertise on it. So why is this document so important? The reality is that in a hospital setting, doctors and other medical professionals deal with a lot of ethical issues and conflicts when it comes to patients that don't have any capacity. Take, for example, a large family with a patient who is dying, and it's the grandmother. When you have a really large family, you're bound to have a lot of people with differing opinions as to how the treatment should be done. So the person who ultimately has the authority, because they're next of kin or people have chosen that person to make that decision, that person may not be the most clear-headed, they may be conflicted, and they may not be able to make the best decision for that patient. It's a very stressful time, people are exhausted, and they just want things to either move forward or not. In a separate example, suppose you have a caretaker who is paid by the state through IHSS. That person's livelihood depends on that patient surviving and living as long as possible. If that caregiver made the decision on behalf of the patient to prolong life as long as possible, that person may be conflicted as well. What are the ethics there? So, an Advanced Healthcare Directive allows the patient to make their own choices, and it allows them to go through the medical healthcare process with dignity. So the reason why I believe this document is such an understated document is because people often think about death and dying as an instantaneous event that happens. But the reality is, it couldn't be farther from the truth. In the end of life sphere, in hospice, dying and the act of dying it's an active process. Sometimes patients have symptoms many months before, weeks before, days before. The body slowly slows down and the body slowly shuts down. So because of this, and because there will be a period of incapacity, however brief or however diminished, it's really important to specify as a patient how you want your health care to be defined when you can't speak for yourself and when you can't advocate for yourself. And also, you want to be able to specify who you would want to speak on your behalf if you can't do so yourself. So today, we're going to go through the Advance Healthcare Directive. It'll be an example form given by the state, published and codified in the Probate Code under Section 4701. And we will go through the document paragraph by paragraph, and I'll show you how it can be filled out and how it could be executed and how you could store it. Okay, so this is what the Advanced Healthcare Directive form looks like. And as I mentioned, this is an example form that was codified and published under California Probate Code Section 4701 and the Healthcare Act. And this is important to remember that this is an example, it's not a model form. And the reason why that is because the state provided laws so that the ultimate authority to make an advanced healthcare decision is within the individual. This form is just an example to do that. So in practice, though, this is a widely used form, and this is also a well-recognized form. When you do end up going to your hospital systems or in a clinical care setting, certain hospital systems may have their own form that they want you to fill out. My advice there is that you absolutely can fill out whatever they want you to fill out. But this form oftentimes is very well recognized by essentially all healthcare professionals in the state of California. So the number one thing I want you to do as you're working through this form is to read this front page set of instructions when it comes to filling out this form. So the entire healthcare directive has got 4 main parts. The first part speaks to you naming an agent to speak on your behalf. And this is the person who either knows you or knows what you want or happens to have subject matter expertise when it comes to healthcare decisions. Part 2 deals with your decision to prolong life or not to prolong life. In practice, this just basically means whether or not you want to stay on life support when that's what's keeping you breathing and your heart beating. Part 3 speaks to your intent to donate bodily organs. Part 4 allows you to designate your primary care physician in this form. So without further ado, we'll just go ahead and start here. So here we are, Part 1, Power of Attorney for Healthcare. So this term is a term of art, and it does have legal significance, but oftentimes it confuses people. So it's not good to think about attorney to mean lawyer. You're better off thinking about this word attorney being used as to have somebody represent you or somebody to speak on your behalf. This is really what you should be going by, the designation of the agent. And the agent is who you select to speak on your behalf, either when you can't speak for yourself because you're incapacitated, or you actually even have the option to let them make decisions for you off the bat, even while you're still around. And I'll get to that option after. So you fill that person's information out here. There are 2 additional blocks, and they're both optional, of course. And these 2 additional blocks allow you to specify backup agents if the person who you've named above cannot be found, or they're for whatever reason unable or unwilling to execute their authority to speak on your behalf when it comes to your health care. Section 1.2 allows you to specify any limitations when it comes to making decisions on your behalf. So for example, if you don't want your agent to make decisions when it comes to your mental health, you could limit that here. The other thing to keep in mind is that this is just an example form. In fact, if you look in the first page of the instructions, it even specifies that you could modify anything on this form. Also, you are free to fill out any part or complete the entire form in its entirety. So don't be shy about this form. Um, you ultimately have the power to specify and define your healthcare. This is just a method to get there. And then this is why there are other forms out there as well. Um, but as I mentioned, this is the example form codified by in the probate code, and this is a widely used and widely recognized form. So here under section 1.3 speaks to when an agent's authority becomes effective. So by default, when you fill out this form and you name an agent, their power to speak on your behalf does not kick in yet. It doesn't kick in until you've become incapacitated. If you mark this box, this means that they would then have the authority to make decisions for you immediately. So certain relations between the patient and the agent may allow this. You know, if it's a husband and wife who's really close, mother-daughter who's really close, then I think there's more reason to justify marking the box. I could also see another situation in which there might be a mother-son where the mother does not speak English very well, for example. Then maybe I'd want the mother to mark this box so that the son could then interface with the doctor directly, as opposed to jumping through hoops to work around the healthcare system to get care for her mother, for example. So there are reasons for the agent's authority to be effective immediately. Section 1.4 speaks to the agent's obligation. So the agent has a duty that they have to uphold and adhere to, and that they have to execute the instructions based on that patient's wishes. So there is an obligation there. Section 1.5 speaks to an agent's post-death authority to donate organs, tissues, and parts. So you could put any limitations on that here in this block. And in part 3 of this form, you could also specify organ donation. Section 1.6 speaks to the nomination of conservator for the purposes of a conservatorship. So by default, whoever you named in this form would also be named as a potential nominee as conservator for conservatorship. So a conservatorship is a court proceeding that asks the court to step in to allow a conservator authority to speak and act on behalf of that person who's being the conservatee, basically. So when it comes to healthcare, if for whatever reason, if there's an outside agency who will not interface with this third party that you've given the power to, and you absolutely need to open up a conservatorship proceeding for that purpose, this may then be the case, and then whoever you nominated here would be your decision to nominate that person is conservator for the purposes of conservatorship. I know that might be really circular and confusing, but if you have any questions, feel free to reach out to me, or you could look up the process of conservatorship as well. These things are often not granted fairly freely. It's a whole process, and it's fairly time consuming. But for whatever reason, suppose while you had capacity and you filled out this form, you were fine. But let's say you got into a really bad car wreck, and you were in the hospital and you left, but you're still alive, and you're also permanently disabled at that point, mentally disabled as well. So at that point, somebody would need to have you under conservatorship to keep interfacing on your behalf for all these other additional needs. So whoever you named in this form would then be your nomination as a conservator for you. So that's how the process would work. Okay, part 2, important decision. This is instructions for healthcare. 2.1 speaks to the end-of-life decisions. If you check A, you would choose to not prolong life. If you check B, you would choose to prolong life. So under A, basically, you do not want your life to be prolonged if, 1, you have an incurable and irreversible condition that will result in your death within a relatively short time, or you become unconscious to a reasonable degree of medical certainty and you will not regain consciousness, or the likely risks and burdens of treatment would outweigh the expected benefits. So that's the rationale for that. And remember, you don't have to be shy. You could actually specify and change and modify the language here. I've had clients who've told me that they want to prolong life up until 30 days. Anything after 30 days, they want to terminate life, or terminate life support rather. So you could absolutely make conditions and write that down in this form. You don't have to adopt 100% of the language here in this form. Section 2.2 speaks to relief from pain. If you want any specific instructions when it comes to pain relief, you could mark in that block here. Section 2.3 allows you to specify any additional wishes you have when it comes to your healthcare. Okay, part 3 speaks to the donation of organs, tissues, and parts at death. So if you mark this box, you would authorize your agent to consent to any temporary medical procedure to harvest your organs and tissues. By default, the donation will be given for transplant, therapy, research, and education. If you want to eliminate any possibility of any of these, you absolutely can by striking or otherwise crossing out what you don't want. And if there's any other restrictions when it comes to donation of organ, tissues, or body parts, you could specify it here in this blank line. So the other thing to keep in mind is if you do leave this part blank, this entire part 3 blank, it doesn't mean that you have refused to make a donation. There is another selection that you've done through the DMV that the hospital might look at. So within your DMV records, you may have signed up to be an organ donor. So they would then pull up the records to see if that is the case. So if you do leave it blank, they'll also check with your records to see if you've signed up for that program. So the one thing you do want to keep a line often is, just make sure that you make this. If you are an organ donor, just go ahead and mark what you would have done. But if you're not, you don't want your organs donated, specify that to be the case. Part 4 is the primary physician block. It allows you to specify who your current PCP is, and if that PCP is not available or doesn't want to act on your behalf, you could absolutely name a backup primary care physician as well. So that's part 4. This is part 5. This is the signature or execution block. One thing to keep in mind is that 5.1 says the effect of a copy of this form has the same effect as the original, which basically means if you come into the hospital with a copy of this form, it should be as good as if you signed this and this is your actual original form. So I've told people to make as many copies as possible to provide to family and friends who might be called upon to help. I've had clients put these in their cars. But now the most popular thing to do when it comes to providing this document to either a hospital system or a clinic is simply to upload this document to your healthcare portal. I feel like those portals are everywhere now. They are fairly convenient, and it's a way for you to communicate with your doctor. So just once you fill this out, once you sign it, scan it back as a PDF and upload it. If you don't know how to do that, or if you're having troubles, my suggestion would be to contact the clinic or the hospital and have someone walk you through the portal system. It's really convenient, and if that fails, just give them a hard copy for them to scan into your file system. So 5.2 is the signature block. This is where you sign and date. 5.3 is where the witnesses sign and date. So the one thing I need to specify and note is that the witnesses that sign here cannot be related to you. They can't be the doctor. They can't be someone who will be able to inherit from you. You want to keep these witnesses fairly disinterested and independent. If you have a hard time tracking these witnesses down and there happens to be a notary nearby, my suggestion would just simply be to notarize the document itself. So there's an additional statement of witness, which basically specifies that you're not related to them and that you're not entitled to that person's estate. So my suggestion would just be to notarize it. So with this document, you either have it signed with 2 witnesses or you can have notarized. It's either or. But if you do go the witness route, the other thing I want to go over is the fact that there is a special witness requirement, meaning if you are a patient and you happen to be in a skilled nursing facility, which is another phrase for a nursing home, you would need a signature from the patient advocate or the ombudsman to sign to make this Advance Healthcare Directive good and executed properly. So yes, this has been the review of the Advance Healthcare Directive. It's fairly straightforward. The instruction page, along with the notary pages, are only 7 pages long. And as I've said, this document is the most important planning document, and it's very understated because there's so much misconception when it comes to a person's health care. There's so much misconception when it comes to a person's death or death in general that this is often neglected. So this is up there with having a will, because this allows you to go through the healthcare system with dignity, and this allows your family and loved ones to honor your wishes from start to finish. and it alleviates a person from having to make a decision that they end up either regretting or second guessing for the rest of their lives. Without any directives or instructions, I've seen families get torn apart at the hospital because of the lack of direction when it comes to the patient. So this is a very important document, and um, it will be good to have for anybody, whether or not you have a really big estate or if you have nothing. At least, if you believe you have nothing that anyone else can inherit, or if you don't think you even need to go through the probate process, this is the one document you need to have then, if you have nothing else. So if you have any questions, feel free to reach out to me. You can email me at will.ha@williamhalaw.com. You can contact me at my office number. And feel free to leave a comment below. And once again, this is for information only. No legal advice is meant to be given, and no attorney-client relationship is formed by watching this video. Thank you very much for watching, and I hope you have a good day.